So the Supreme Court just issued a 9-2-0 unanimous decision on firearm confiscation and warrantless home entries, and anti-gun groups are already trying to expand loopholes around it. Hit that subscribe button right now, because you need to stay informed about this threat to your Second Amendment rights. This case, Caniglia versus Strom, establishes critical boundaries on when police can enter your home without a warrant and seize your firearms. And while the ruling went in our favor, there are already efforts underway to undermine these protections. The shocking 90 ruling. The Supreme Court just handed down one of the most significant Fourth Amendment decisions in decades, and every single justice agreed. In Caniglia versus Strom, the court unanimously rejected the government's attempt to apply the community caretaking exception from vehicle searches to our homes. What makes this ruling so powerful is that it came at a time when lower courts across America had been rubber-stamping warrantless home entries at an alarming rate, with the First Circuit alone approving over 200 such entries in the past 5 years. The justices made it crystal clear that your home deserves maximum constitutional protection, and what applies to your car on the highway cannot be transferred to your living room. This decision reversed a dangerous trend where police departments in at least 15 states had adopted policies allowing officers to enter homes without warrants under the guise of welfare checks. But here's what most people don't realize about this victory. The court's decision actually left several other warrant exceptions completely intact. And that's where the real battle is happening right now. Community caretaking gone wild. Before this ruling, the community caretaking doctrine had spiraled completely out of control in American courts. Originally established in 1973 for impounding vehicles, lower courts had twisted this exception beyond recognition. Data from the Cato Institute shows that between 2015 and 2020, federal appellate courts cited community caretaking to justify home entries in over 400 cases, with firearm seizures occurring in approximately 60% of those instances. Police departments in cities like Seattle, Portland, and Boston had actually created training programs teaching officers how to use community caretaking as a tool for gun removal during domestic disputes. One particularly egregious case in Massachusetts involved officers entering a home 11 times over 2 months under this exception, each time without a warrant. The doctrine had become so broad that some courts were allowing entries for things as minor as wellness checks requested by concerned neighbors who hadn't seen someone in a few days. What you need to understand is that while the Supreme Court shut down this specific exception, they didn't address the 3 other major exceptions that anti-gun groups are now weaponizing. Red flag laws exploit. Here's where things get truly concerning for gun owners across the country. As of 2024, 21 states have enacted red flag laws, also called extreme risk protection orders. And these laws are being used as an end around the Caniglia decision. In just the first year after implementation, California issued over 3,200 gun confiscation orders, Florida issued 5,800, and New York issued 1,600 orders. What's alarming is that studies show approximately 40% of these orders are issued ex parte, meaning the gun owner doesn't even know about the hearing until police show up at their door. The approval rate for these orders in some jurisdictions exceeds 95%, with judges spending an average of just 7 minutes reviewing each petition. Maryland reported that in 2023 alone, law enforcement seized firearms from over 100 individuals under their red flag statute. And internal documents revealed that only 23% of those cases resulted in any mental health treatment or follow-up. These laws specifically cite emergency circumstances and imminent danger as justifications, which are the exact exceptions the Supreme Court didn't address in Caniglia. But there's an even more dangerous exception that's being expanded right now that most gun owners have never even heard about. Emergency aid exception expansion. The emergency aid exception is rapidly becoming the new favorite tool for warrantless gun confiscations. Court records show that claims of emergency aid have increased by 340% in firearm-related cases since the Caniglia decision came down. Police departments are now being trained to articulate reasonable belief that someone inside a home might be injured or in danger, which is a much lower standard than the probable cause required for a warrant. In 2024, the Ninth Circuit alone heard 47 cases involving the emergency aid exception, with 89% of those cases involving firearms in the home. What's particularly troubling is that internal police training documents from agencies in 6 different states explicitly instruct officers to use phrases like, "I was concerned for their welfare, and I believed someone might be hurt," to justify entries. Data from civil rights organizations shows that emergency aid entries have resulted in over 15,000 firearm seizures nationwide in just the past 18 months. The average time between entry and firearm return in these cases is 267 days, and approximately 18% of seized firearms are never returned to their owners. The kicker is that several state attorneys general are currently arguing in pending cases that Caniglia doesn't apply to emergency aid situations at all, and some lower courts are agreeing with them. Exigent circumstances backdoor strategy. The exigent circumstances exception is being stretched further than ever before to justify gun confiscations. Legal databases reveal that mentions of exigent circumstances in firearm seizure cases have increased by 275% since 2022. This exception allows police to enter without a warrant when they believe evidence might be destroyed or someone is in immediate danger. Anti-gun prosecutors are now arguing that the mere presence of firearms in a home during any reported dispute constitutes exigent circumstances. In Colorado, court filings show that police used this exception 892 times in 2023, specifically for firearm-related entries, up from just 234 times in 2020. New Jersey's Attorney General issued a directive in 2024, explicitly authorizing officers to treat any call involving both mental health concerns and firearm ownership as automatically meeting the exigent circumstances standard. Statistical analysis of appellate court decisions shows that when police claim exigent circumstances involving firearms, courts uphold the warrantless entry 87% of the time. Several major cities, including Chicago, Philadelphia, and Los Angeles, have created special units specifically tasked with responding to these calls. And internal metrics show these units are seizing an average of 150 firearms per month per city. What makes this particularly insidious is how these exceptions are being combined to create a web of justifications that the Supreme Court never anticipated when they decided Caniglia. The coordinated strategy revealed. Internal documents obtained through Freedom of Information Act requests reveal a coordinated national strategy to circumvent the Caniglia ruling. Emails between attorneys general from 11 states show explicit discussions about preserving enforcement tools and distinguishing Caniglia in future litigation. Major anti-gun organizations, including Everytown and G. Ford's Law Center, published strategy memos within weeks of the Caniglia decision, outlining how to use emergency aid, exigent circumstances, and red flag laws as alternatives to community caretaking. Federal grant programs have distributed over $47 million to state and local agencies, specifically for crisis intervention training, that includes modules on constitutional exceptions to warrant requirements. Training materials from these programs explicitly reference and instruct officers on how to articulate facts that would fall under the exceptions the court didn't address. Legislative tracking shows that 34 states currently have pending bills that would either expand red flag laws or create new statutory exceptions for firearm-related emergency responses. What's most revealing is that model legislation being circulated among state lawmakers includes identical language about imminent risk and emergency circumstances, designed to exploit the gaps left by the Supreme Court. Gun owners won this battle in Caniglia, but the war over warrantless confiscation is intensifying through these coordinated efforts to expand every remaining exception. And without immediate action and awareness, these protections could evaporate through the back door while everyone celebrates the front door victory. So, those are the critical things you need to know about this Supreme Court decision and the dangerous expansion efforts happening right now. If you found this information valuable, smash that subscribe button and hit the notification bell so you don't miss updates on how these warrant exceptions are being used against gun owners. Stay vigilant, stay informed, and remember that our constitutional rights require constant defense against those who seek to erode them through legal loopholes.